Okay, folks, this video is part of Note 7, Week 7. We're still on First Amendment issues, freedom of speech. And what I would like to do today is just go over the second handout I gave you in that area, which was entitled Other First Amendment Freedom of Speech Issues. We're going to kind of just run through a number of exceptions to the First Amendment freedom of speech. The different exceptions that have been found by the court over the years. First, something called incitement. This is limited to speech which creates a clear and present danger by instigating violence, riot, or criminal insanity. Has recently been tested in Massachusetts in the case of Commonwealth versus Carter, decided in 2019, where a young woman incited her boyfriend to commit suicide and was found criminally responsible for what amounted to speech alone. The Supreme Judicial Court of Massachusetts upheld that conviction, and the Supreme Court of the United States refused to take certiorari. So that stands. So even inciting somebody to take their own life, egging them on, coaxing them on to do it, even though you use nothing but words, that is an exception to the First Amendment freedom of speech as it stands. Of course, obscenity is an exception to freedom of speech. The difficulty is trying to determine what is obscenity and what is not. In the case of Miller versus California from 1973, one of the most famous Supreme Court cases dealing with obscenity, the court tried to lay out some standards. They said that you needed to find that the average person applying community standards would find the work as a whole to appeal only to a prurient or sexual type interests, that the work depicted or described was patently offensive, either by sexual contact, excretory functions, but these had to be specifically defined by state law. So the activities that were patently offensive had to be stated in the statute that was trying to limit obscene materials. And then they had to look at whether the work taken as a whole lacked any serious artistic, political, or scientific value. If it had any value in those areas, then it could not be prohibited. The reality is, the obscenity laws really could only be enforced at a time when people had to go outside of their homes to purchase obscene materials or to go to a venue where obscene materials were being displayed. With the advent of the internet, most public and police type efforts, criminal law enforcement efforts to prevent obscenity have basically collapsed, as people can now download or stream whatever they want to look at in their own homes, and it can be materials derived from anywhere on the planet, very often outside the jurisdiction of the United States. My sense is, even though the laws are still in the books, they're almost universally not enforced at this point in time. Now, the great exception to that is child pornography. Any depiction of sex acts or lewdness showing the genitalia of persons below 18 can be prohibited. Does not matter if it was done in public or private, and possession of these materials is as criminal as making them. It is all possession, creating, buying and selling, trading, transferring are all felonies under federal law and under many state laws. This is not seen as an exception to the First Amendment necessarily in the way the courts analyze it. They look at this as a child protection thing, that a child under the age of 18 is unable to give full consent to have their image taken and used in this type of way. Fighting words. Chaplinsky versus New Hampshire in 1942 said that the state could prohibit words which were intended to provoke violence or an immediate breach of the peace or a violent reaction. Speech owned by others. Now, we didn't talk a lot about this, but it is an interesting area. Words, works of art, music, literature can all be copyrighted, or a trademark or a patent can also be subject to government control and regulation and to private ownership. And there are certainly criminal and civil penalties when you attempt to use items that might be considered speech, but it is speech that belongs to someone else. It is an idea or a thought or a work of art that belongs to somebody else. If it is patented, copyrighted, or trademarked, you cannot use it without permission of the owner. Commercial speech. Much of what we've been talking about so far has to do with political and religious and social speech. Commercial speech is a speech used by people in their businesses, particularly has to do with advertising. And the courts have long held that the First Amendment applies much more lightly here than it does in the political, personal, religious realm. So that certainly false advertising, misrepresentation, consumer fraud can all be regulated to protect the buying public from suffering losses. Defamation, we had talked about. Libel is written words intended to disparage the character and social standing of another. Slander is spoken defamation. At common law, these were actionable. You could sue for damages. The only defense was truth. The Supreme Court has restricted this somewhat. In New York Times versus Sullivan, they ruled that in order for a public personage, and that would be actors, politicians, religious leaders, sports players, anybody who is in the public eye, and particularly if they want to be in the public eye, they can only bring a suit for defamation if they can prove that the information was known to be false by the speaker and was still published anyways with malice, which basically means with evil intent, not by accident or not with an uncertainty or unsure of it being untrue or that. So there is a great deal of freedom for the press and for the internet and the public media operations to be able to say just about anything they want about famous people, because it's very hard unless you can prove malice, which is again one of those crimes that deals with intention. Intention is often difficult to prove. You cannot recover in defamation any longer if you're a public person. Speech is also indirectly controlled by the government in a number of ways. The airwaves, over-the-air radio, TV, and now moving into cable television, which is a government regulated utility. All of these things can be controlled and regulated on the idea that the airways are a public trust. They belong to the people, and the government has the right to control them. In education, in kindergarten, grades 1 through 12, schools can impose certain limited free speech restrictions, although not all. If we think about the Tinker case from the 1970s, the students were allowed to have the symbolic speech of wearing black armbands to protest the Vietnam War, and the school was not allowed to stop them. However, school authorities do have the right to supervise student newspapers, yearbooks, publications, and other types of things on the idea that they stand in parent patriae. They stand in the place of the parents of minor students, and they have the right to exercise certain control for the students' well-being and protection. Attorneys are subject to regulation of the court, and particularly in terms of advertising. For the longest time, there was a complete ban on attorney advertising by almost all states. That gradually loosened up, and the Supreme Court finally ruled that a ban on all advertising is too broad, but attorney advertising is still fairly strictly controlled. In the military, active members on military duty must follow military rules and orders concerning speech. Basically, by entering the military, you have limited your First Amendment right to free speech to a certain extent. Prisoners, anyone who is incarcerated in the criminal justice system, correction officials have a large, broad powers to control and regulate speech, to see what materials go in and out of the prison, what contacts are made and not made. Immigrants. Speech made outside the United States can be a reason to refuse you entry, to deny a visa, or to deny a green card. Speech and actions. Parades, marches, protests, demonstrations, picketing can be limited by the government as concerns the time, place, and manner. So even though you have the right as part of your freedom of speech to engage in these activities, the police powers exist in the state and local governments to make sure that these are done in such a way that they do not create a danger, they do not disrupt society or other citizens who are not involved. They cannot regulate the content of the message, and they cannot totally, completely prevent such activities on the basis of some kind of protection of public safety or health. Um, any restrictions must be reasonably related to health, public safety, and welfare, such as you cannot picket, or as we've seen in Rhode Island lately, you cannot promote your cause by standing in the middle of 295 in Providence or 95 in Providence and attempting to block the highway at any time of day. So, again, just a quick run through of the major exceptions to the First Amendment when it comes to the freedom of speech. I'm going to stop now, and we will be moving on still in topic 7. We'll be moving on to religious freedom and the First Amendment as it concerns religious liberty.